matter of Barrowfen Properties Limited and Patel.
Mr. Stewart.
Well, there should be on your desks a document headed Breakdown of Valuations, which I'm just going to address you on
Yes.
briefly in a minute. Can I just tell you where I'm going this morning? I'm going to deal with that, which is really just to identify what the reasons are for the differences between the amended original valuation and the revised development scheme valuation, and it's conveniently done by this table. Then I'm going to seek to address the question which I think Lord Justice Snowden was putting to me in various different ways, which is why, if the scheme is, this is what I understood the question to be, he'll tell me no doubt if I've got it wrong, which is why, if the scheme is worth more in March 2021, the finance costs going to completion show different figures. So that's the question I'm going to seek to address. I'm then going to briefly address the authorities in relation to the issues which arise on my learned friends appeal, and then I'm going to turn to our appeal, which is whether you take the whole of the credit or a proportion of it, and then I'm going to sit down and you're going to hear from Mr. Polkard. Can I just first of all go to this document, and it really seeks to summarise the submissions that I was making yesterday, and can I just tell you how it works first of all? What we've got is the elements of the different valuations in the first column, and obviously the hotel, the community space, the retail space are common to each of the developments. The student space appeared in the amended original scheme, but not in the revised development scheme, and the residential and social housing appeared in the revised development scheme, but not the other. So that's how the elements break down. I then put down these square footages. Now these square footages are taken from Mr. Alford's report, and they were the ones which were used, and you see S83, the original amended scheme, down the first column, and then if you go to the fifth column, you'll see the equivalent square footages for the revised development scheme. Just pausing there, both valuers gave gross and net figures. In all cases, the gross and net figures were done on a formulaic basis, 85%, so it doesn't matter whether you take the gross or the net, you simply get a mathematical adjustment according to the differences. I've excluded from this table the facade, which appears in both elements of valuation. That's because it wasn't usable or valuable space and no value was attributed to it, but just so you know that the facade was actually slightly different in the two different schemes, and you can see that. So you've got here the income generating or capital generating parts of the report. Then I've got the valuations which the judge used, and so for the hotel, in relation to the amended original scheme, he arrived at a valuation, and I've given the reference, judgment at C473, that's the table which you're familiar with, at 9,502,618. I then simply identified on a mathematical basis what that means in pounds per square foot. So I've divided 9.5 odd million by 35,1,077. So the hotel was being valued on a pounds per square foot basis in the amended original scheme at £270 a square foot. Now, it's been done on a rental and yield basis, but that's just what it breaks back to. What you then see in the revised scheme is that the square footage of the hotel has actually increased by just over 9,000. You see that the valuation, however, has stayed pretty well the same. In other words, it's gone from 9.5 million to 9.46 million, and the pounds per square foot has therefore come down. And the reason for this, and you can get this from the judgment with the references, is that the yield went out between that period from 5.25 to 6.5%.
Just so we're clear about what you mean by yield, can you just define yield?
Yes. The yield is the inverse of the monies purchased, so that if you have a yield of 5% and a rental of £100 per year, you multiply £100 a year by 20 in order to get the sum of £2,000 as being the capital value. And therefore, when the yield comes down, if the rental is the same, the value will be higher. On a 1% yield, you're paying 100 times the annual rental value. On a 5% yield, you're paying 20 times the annual value. On a 10% yield, you're paying 10 times the annual rental value.
It's, so to speak, the return you expect to obtain on what you're paying.
Yes, or
as a percentage,
or your income you're receiving. Yes.
And what factors drive the determination of yield in that purpose? Is it risk of?
It's a series of things. It's risk. It's the cost of money. It's risk covers a whole series of factors. So that, for example, perceived risks. If you think that the value of your rents is going to go up very markedly, then your yield will come down in order to reflect, I say you, if the market thinks that the value of the rents is going to go up, then everything else being equal, the yield will come down, because it's saying you've got an income at the moment of X pounds per year. We're thinking that that's going to be X times 2, and therefore you pay more for the current income than you would otherwise do.
And otherwise, as you say, it reflects cost of money.
It reflects the cost of money, interest rates. I mean, it obviously reflects where people think interest rates are going to be going, and it reflects overall risk as well. What you pay if you're investing in some unstable Ruritanian republic like Texas. Sorry, that's a joke. You're going to have a higher yield than if you have an extremely stable country like France.
And when you talk about the cost of money, again, just explain cost to whom of what?
It's the notional cost to the purchaser of the money. It's also a reflection, I don't want to oversimplify this, of what you could get on your money elsewhere. So if you can get a 2% real return by putting money into government bonds, you're going to need to get more of that by way of a return to justify investing on everything else being equal.
So in the yield figure, and hence in the gross development value number that you arrive at, is a factor which essentially looks at the costs to a potential purchaser
Yes.
of financing
Yes.
the acquisition of the property.
Yes. Yes.
So if I was to put it this way, that the gross development value, which is what we're talking about here, which we get to at the end of the day, which drives the developer's profit, which is what we're arguing about here, includes a factor which reflects the cost to a hypothetical purchaser of buying the
Yes.
development.
Yes. The cost, or what else you can do with his money. Because if you imagine a hypothetical purchaser, they may either be borrowing or they're looking at alternative
So
investments.
it is already factored into the gross development value.
Yes, that feeds into that by way of the yield. And so, in very simple terms, in valuing retail space, in valuing commercial office space, those valuations are done on a rental and yield basis. You look at how much rent you're going into, and then you look at the yield. And in very simple terms, if you've got prime property which is in central London in normal times, that will have a lower yield than secondary property in central London, which will probably have a lower yield than property in Hartlepool, everything else being equal. But there may, of course, be exceptions to that for all sorts of reasons. Just coming back to the hotel, my learned friend, if I may say so, very fairly, withdrew the suggestion that they had taken the point anywhere that the relevant comparison should have been at 2021. You saw that that was put forward as a reason not to give permission to amend, but it wasn't put forward in the pleading which followed. It wasn't put forward in the expert evidence which was served after it, and it hasn't figured in any of the arguments to date. Now, why they don't do that again is, of course, something which we can't know. The one obvious point I would make is that if you look at what the judge says in relation to, for example, the hotel, although the rental income had gone up slightly, the yield had pushed out from 5.25% to 6.5%. And just to show you what effect that would have had on the hotel valuation, if you use the same rental as September 2016 for the hotel at 35,177, but you change the yield, the effect of that is to push down the value from 9.5 million to 7.6 odd million pounds. So that shows you the effect of the yield. And the judge expressly says that that is attributable to the state of the market in March 2021, when, of course, one is in the middle of COVID and one's got those considerations. Now, my lords, you haven't got the evidence down before you, but we would certainly say that it would be a little bit cheeky in those circumstances to suggest that actually the comparison which is being taken place between these two schemes is likely to be adverse to his clients when one sees what the effect is on yields in relation to like-for-like matters. The student accommodation is obviously only in the original valuation, amended original valuation. It is 35,392 square feet, and that is £263 a square foot. It's put in at a yield of 5%. If you then look at the essentially what that is replaced by, essentially that is replaced by the combination of the residential open market accommodation, which is 25,692, and the social housing, which is 7,208. And as I'm sure your lordships know, if you get permission, very generally, if you get permission to do substantial residential development, you have as a consequence of that to produce social housing. And so what happens is that those two amounts, the 25,692,000 square feet and the 7,208, essentially replace the student accommodation. And what you see in relation to that, and these are expressly valued on the basis of assumptions of the sale of long leases, is that you get valuations at £698 a square feet for the open market and 472 for the social housing. Now,
and that's on the basis of comparables?
That's on the basis of comparables, and it's done at March 2021. And just to be clear, the judge accepts Mr. Alford's figures. I've identified where that is. The judgment doesn't actually break those two down, but you can see that he accepts Mr. Alford's figures, and that's how it breaks back. And the obvious point to be made, therefore, is that the biggest single difference between these valuations is that instead of student accommodation at £263 a square foot, you're looking at residential accommodation at, in the case of the open market, over twice that, and in the case of the social housing, about 1.5 times that. The retail space, they've managed to get another just over 2,500 square feet out of the retail, and one sees that the rentals have in fact gone up, the space has gone up, the yields have pushed out from 6 to 7%. So that's why you get the difference between 7.5 million and 8.68 million.
So the yields have gone up, rather than use the expression pushed from. The yields have gone up because what the hypothetical purchaser is presumed to regard it as a more risky investment in retail.
Yes, exactly.
And so requires a higher yield on
the
return on his financing,
yes,
to justify taking a greater risk.
Yes, and what's happened between 2016 and 2021 is that the residential rents have increased. So there's been some inflation in terms of the rents. You've obviously got more space, so you've got more lettable space. But as you say, and as the judge attributes, retail is plainly under pressure. This is March 2021. People are sitting at home, not going and shopping in. I was going to say Woolworths, but I'm sure there isn't a Woolworths in Tooting. But your lordships have the point.
So to the extent that it matters, and I'm not sure it does matter, you would say, well, if you had been valuing the retail element in 2019 on the basis that was used in 2021, you would expect to arrive at a lower figure rather than a higher figure.
Yes, that's right. Now, to the extent that it matters is absolutely right. But I was just analysing, as it were, where you get to. So then if you just look and see where the differences arise, the first thing they've managed to do on this planning commission is they've managed to get 102,000 square feet of developable space instead of 94,000. So they've managed to actually get a developable area which is 8.6% greater than they've done before. As any property developer will tell you, everything else being equal, if you can develop more space, you've got a more valuable property. The second, and as I've already said, actually the biggest element is substituting the residential for the student accommodation. That's what, in essence, you've managed to do. You've got accommodation which you can sell if you want to. Now, just pausing there, you're then left with a capital value, and these are the judge's figures, which is 47.2% higher in March 2021 than it was in assumed to be in September of 2016, and we've discussed the reasons for that. Just however, pausing in relation to what you can do with this property, which was a question which my Lord Justice Snowden was asking a learned friend yesterday, you could obviously sell the whole thing. You've got to sell the social housing because it's a condition. You can sell some.
When you say you've got to sell the social housing, do you have to sell it, or do you let it on assured tenancies or whatever it is? I mean, do you have to sell it?
I think you have to sell it to a social housing operator, but I can check the terms of planning conditions.
Oh, and then they rent.
Yes.
So it's like a housing association or such.
I think
Meaning on a long lease, not freehold.
Yes. Oh, yes. When I buy and sell it, I mean obtain substantial capital value from a long lease. You're obviously not getting rid of part of the freehold in relation to it. But I can check it. But my understanding is that you have to sell to a designated or
Housing association.
Housing association who can then operate the social housing elements of it.
Right, and you do so under a long lease rather than and they grant sub-leases or short-term tenancies or whatever.
Yes.
All right.
Yes.
Broadly. Yes. Okay.
Now, my lord.
And the residential you grant, did you say long leases? Yes, long leases.
Well, these valuations are done on the assumption of long leases. But as we shall see in a minute, what Barrowfen are saying is they don't want to sell the residential. They want to keep this residential accommodation. The point I'm making is that they can sell the whole of the development. They can sell, not sell the whole of the development, or they can sell some of the residential space. And just pausing there, the residential space, excluding the 7 of the social housing, is a tad under £18 million. So just looking at the choices that you've got as an owner in relation to this property, if you want to, on this 40.2 million valuation, you can reduce the extent of the investment in broad terms by just under £18 million, and you pull the amount back to £22 million. So you have got a very attractive and flexible investment. Now, my lord,
But of course, initially they never had any intention to have residential property at all. Actually, the 17 million is the thing that, because they had to put in the revised plans because of the delay, because of the breach.
right, so
That's the thing that is new and
it's the biggest single change. The changes, as I've sought to identify, they've managed to sweat a little bit more residential space. They've managed to sweat a little bit more hotel space. But the biggest factor is getting.
And that wasn't something that was in the original plan.
It wasn't.
I mean, broadly speaking, you let to students on short.
Yes, the evidence
tenancies.
was that you let to them. You get, I think, 8 months, or possibly 9 months. I can't remember of income per year, because and you try, if you're lucky, to get a bit of income over the summer from whoever will pay you anything.
And I hadn't thought this through properly. So the assumption on the claimant side, and I dare say the reality, is that the residential is being let out on short-term tenancies.
I assume so, but we don't know.
No.
I mean, they can do what they want to do.
Yes.
One assumes that they're letting it out on non-rent act protected terms, and it's being done on that basis, and they're achieving a rental income from it.
Yes.
My lords, I wanted to show you that just so that you can, as it were, understand what's going into the figures which you've been looking at, and I hope that's helpful. I've given the references there and identifying where the numbers go. I make two substantive points. One I've really made already, which is the real differences are the ones I've just identified, and I won't go over them again. The second is that the learned friend's absolutely right not to be pressing the point about the difference between September of 2016 and March of 2021, because the likelihood is that if he did so, what you'd find is actually the value of that had gone down, not the other way around.
But I mean, Mr. Kramer's sort of bald objection to the judge's judgment is the judge assumed a sale when he should have assumed it was being retained. Your point is that that's, I think, is that's far too simplistic on the facts, because it is inevitable that to some extent there is a disposal of this of interests in this property to a greater or lesser extent.
Yes, I mean, it was accepted that they have to get rid of the social housing. That was
So it's not, quote, an asset which you keep. Inevitably, you have to dispose of interest to get a return. And the whole concept of developers' profit is based upon a notional sale in the market, because that's the gross development value, which is less the costs, gives you the developer's profit.
Yes, absolutely. And when you're looking at
and so he should, the follow through is either conceptually Mr. Kramer should be objecting to the whole exercise of making any deduction for developer's profit.
Yes, he should be.
Which he isn't.
No. And he can't do that. And just to be clear why he can't do that. He can't do that because if he does, he's going to have to come and say what it was that Miss Hilliard was saying beforehand, which is that none of this was causally the consequence, legally the consequence of my acts of negligence. The consequence of that is that he doesn't get 54 months worth of loss of rent. He only gets 24 months of loss of rent. He doesn't get the £399,000, which he's got for changing the development over, etc., etc. And he's less than some. He ends up with less than the sum he first thought of. And that is why Mr. Kramer's attractive and beguiling submissions tread such a narrow and careful path in relation to what has happened here. I can stand here and think, oh, shall I actually have said, no, Miss Hilliard's absolutely right, all of this is not there, etc., etc. But as you perhaps remember, it's a bit like reading one's own cross-examination. You always think about whether or not questions could have been phrased a bit better. But there we are. They can't now be heard, and they don't, to be fair, say that the legal consequences of doing the development are beyond the scope of what is asked for, because that would be completely inconsistent with what they say. Well, that's all I propose to say in relation to that table. But what I do want to do is just chase down this hare in relation to profit and profitability, if I may, and just trace it through so that I hope your lordships understand what the judges are saying. Can I just mark at this point? I am going to be taking you in a few minutes to some other parts of Lord Legate's judgment in Stanford, which do elucidate what is meant by reasonableness in the context which is being put forward. And I'll just flag that up, but it's particularly relevant to the case which is now being put, where he said, to use my Lord Justice Snowden's remark, we're deeming a sale. We're not deeming a sale at all. We're simply saying that the causal consequences of our loss, of our negligence, came to an end in March 2021, at which point these people had a free choice as to what they wanted to do. And after that, the consequences of that free choice redound to their credit or their disadvantage. If the value of property in Tooting multiplies by 5, good for them. If it halves, tough luck.
Your point is there's no deemed sale at all.
Absolutely.
What there is a valuation of an asset.
Exactly.
What people do at stage 2, right, if that's what the asset's worth, what should I do with it now? Sell it, split it up and sell some and keep some. Up to then, that was the point you began with yesterday.
Stage 2 of the Lord Toulson analysis,
exactly,
which I showed your lordships yesterday.
Yeah. It's the valuation of an asset.
Yes, and just to be clear, valuation of assets for which there is an available market. I mean,
Yes.
it's you can sell property. Can I then please just deal with the points which my learned friends make about the difference between profits and profitability? And what I think started, or where my learned friends started this hare running, was by reference to the table in the reserved matters judgment at paragraph 36, at tab 19, page C558.
Sorry, could you give me the paragraph number again?
Paragraph 36, my lord, C558.
I have no idea why, but I'm not sure my numbering always corresponds to everybody else.
Oh, it's always good to have a rogue one around the house, especially if it's the presiding Lord Justice of Appeal who've never inhabited the particular wild card. I'm sorry about that.
Anyway, that's fine.
I'm sorry, I was intended to be quite as facetious as I now, but I am sorry. If your lordship can tell me what the difference is, I can try and make
Don't worry.
Paragraph 36, this is the table. And this is
table 3, just to be clear.
Table 3, yes. And this is the table which produces, as the result, minus £959,000. And I just want to be clear as to what this table is actually showing you. It is based on the evidence on Powell 1 as to the increased finance cost of the revised development scheme. That's item number 4 of 1.579, and the increased notional equity costs of the revised development scheme. So that's how you get from the 2508 used by the judge down to the minus 959. Now, those are actually measures not of profit at all, but of profitability. And you see that from the judge's findings at paragraph 29 at C556.
Just so we can be clear, when these are the finance costs over which period?
These are the finance costs. I'm going to come to that in a little bit. It's a very important point. These are the finance costs, assuming that the property is held for 25 years.
That's what I thought you were saying.
In other words, you are locked into this investment. And that, of course, is complete nonsense. I mean, it's complete twobbledygook. There was a passage where the judge said, I took it as a compliment that with characteristically something or other, I made the point. But the idea that you're locked into this property in 25 years is simply nonsense. You're not. And the idea that Prashant Patel would be locked in and say, oh, I'm not accepting this money if you get a suitable offer is also complete nonsense. So what my learned friend is actually trying to do is to say, you should value damages as if, contrary to the facts, we are forced to retain this property for 25 years, which is, of course, complete twaddle.
And just to be clear, in terms of the figures we see for increased finance costs and increased notional equity costs, do they at least take account of the sale of social housing?
I actually don't think they do, but I'll come to that in a minute. I'll show you why I don't think they do.
Can you just help me as well with what's the initial equity cost? The increased finance costs, I understand. That's the money they're going to have to borrow. So
Can I
do it at a later stage? But bear in mind, I don't understand it.
Well,
and I may never need to, but if I ever do, wake me up and tell me.
Can I come to that?
Yeah.
For two reasons. I'm not sure I understand it.
Oh, right.
And secondly, I will, however, show you everything there is to see about it. Now, the table 2, which is there, shows, as you see, Mr. Powell's instructions were to assess the impact of the finance costs associated with each scheme on their overall profitability. And he says in Table 1, it was his evidence that the revised development scheme was less profitable than the overall development scheme when measured either by return on total capital employed or return on equity.
Sorry, I've lost where you're reading.
I'm reading from just above Table 2, paragraph 29, my lord.
Sorry. Sorry.
Page C556.
Yeah, you've gone back. Okay, yep.
And what you see is that the revised development scheme produces a return on equity of 2.26, and the amended original development scheme provides 3.15, and therefore, in simple terms, you multiply your equity by 2.25 times under the revised development scheme, and you multiply it by 3.15 under the amended original development scheme. You've got two thumping good investments, but one is better in terms of this than the other. Now, one can obviously take absurd examples in relation to this, but this is pretty well meaningless. If you have, for example, a garage in Streatham where you get the opportunity to buy it and do it up and make 1,000% return on your capital, so you end up with something which is worth £100,000, or you get the opportunity to buy and do up Canary Wharf, where your return on your capital is a factor of 2, but you end up with something which is worth £10 billion. Which would you prefer to have? I mean, that's the sort of exercise which one is going to. The other thing I should say is this.
Sorry, can I just stop you? At the risk of stating blinding the obvious, and it maybe I'm just being slow again, but this is dealing with an analysis of the value at completion.
Yes.
And looking backwards, as it were, to the return that gives to the people who have invested or contributed their finance or equity to that completion.
Yes, and also looking forward on the assumption, which I'll come to in a minute, that you continue to hold this. Oh, sorry, this table doesn't.
I was going to say, Table 2 doesn't.
No, this table
it's Table 3 that looks forward.
No, you're right. You're absolutely right. Now, what this shows, just in simple terms, is that you've got two. My lord, sorry, I was danger. If you hadn't called me up, I would have been misleading you. What this shows, as I say, is you've got two thumping profitable developments. One was more profitable than the other. Just to be clear, and this is quite important, at one stage there was being floated around the possibility of Barrowfen asserting that by reason of having to put additional capital and or make additional borrowing for the purposes of the revised development scheme, they lost the opportunity to make money elsewhere. And that was expressly disavowed, I mean, unsurprisingly, because if they had an alternative opportunity to make the same sort of money, there was no possible way that they weren't going to be able to generate funds to do so. To be fair, it's always very difficult to show that, because if you've got a profitable scheme and so forth, but they expressly disavowed Now, if you then look at the cost of the finance cost going forward, you have to look at the reserved matters judgment, paragraph 33 at C557. And you see both expert valuers adopted the conventional methodology of calculating the capital value of the treating property at the completion of the relevant development by capitalising the future income stream and then deducting the development costs. But it was common ground that those costs only included the cost of financing development until completion, for the reasons I've set up above. Again, because there's no dispute, it was unnecessary to decide whether a calculation ought to have taken account of the future costs of either funding either scheme. Well, I don't quite know why his lordship said that, but frankly, if he had done that, it would have been completely absurd if you're looking at the value of it. But he doesn't do it, and he raises that particular hair. If you then go forward to paragraph 37, which is immediately below the table we looked at, Mr. Powell accepted in cross-examination that his assessment of the future finance cost assumed that Barrowfen would hold its investments in the Tooting property for 25 years, even though it could be sold at any time after completion. And you see me cross-examining him. The first question at lines 1 to 3 are the questions which establish that he's assuming you can hold the investment, you're going to hold the investment for 25 years. And then I say this at the 5th line, just to be clear, what that therefore means is this. You're looking at two different investments, let's say. You're assuming you hold one of them for 25 years. It's obviously the case you can sell either one of them, certainly when the development is completed. Do you agree? Yes, you could sell it when development is completed, you could sell it partway through, you could sell it at any time. Yeah, just in relation to selling it, market economics dictates, does it not, that if you had an asset and you think you could obtain greater profitability on that investment elsewhere, you can sell it and buy what you think is going to be more profitable. You certainly can, yes. And what your figures are essentially saying is that over the course of a 25-year lifespan, one theoretical development might have been more profitable than development which we've heard is just coming to a conclusion. I think if I understand the question correctly, I think that's right. I'm trying to assess two different projects over a 25-year period, taking into account the financing cost to see whether one would generate more profit in current value terms than the other. And then Mr. Isaac's evidence was that the cost of equity, which was what my Lord Justice Lewis was just asking about, was simply a measure of the return paid to shareholders by way of dividends or a measure of profit distribution and would never be taken into account in the development's profit. You see that at paragraph 42 of the judgment. Mr. Isaac's evidence was cost of equity was the cost which a company had to pay to attract investments to shareholders. Although it was called a cost, it was really a measure of return. He described it as a measure of profit distribution. It was his evidence that it would never be appropriate to include the cost of equity in a calculation of development's profit. You see him saying that. And you also see that he didn't accept that it was appropriate to include maintenance costs after the completion of the development as a matter of logic. You see that in paragraph 44. Mr. Isaacs didn't accept it was appropriate to include finance costs after completion of development as a matter of logic, except the buyer might approach evaluation in that way. And what we say is that Mr. Justice Leech essentially accepted that evidence, and we get that from paragraph 55, where we see C569, like Mr. Isaacs, I'm not sure where Mr. Powell's calculations take me. What his evidence shows is that the revised development scheme is slightly less profitable than the amended original scheme, which would have been, but only has been implemented in 2016. But it's important not to lose sight of the fact that it was a profitable scheme and an attractive investment, and that Barrowfen got a very substantial return on its entire investment, including the additional capital investment. If Prashant had been carrying out the kind of cash flow forecast which Mr. Isaacs described in 2016, he'd still have been satisfied the revised development scheme was profitable. It was worth making the additional investment.
And just if I relate that back to table 3.
Yes.
A key point there, as I understand it, is that entry 5, the increased notional equity cost, is simply an opportunity cost.
Yes.
That's saying what else you could have done with the money.
Exactly.
So if you take that figure out, then it is profitable.
Yes. Yes. Yes, exactly, Mike. Now, my lord, I mean, there are all sorts of other things which go wrong with this. It takes out of account the possibility of refinancing at lower rates, takes out of account all sorts of opportunities and so forth. I mean,
Sorry, can I just ask, when you talk about profitable there, is he not just talking about the difference between the developer's profit for the two schemes?
Sorry, where, my lord? When you say...
In paragraph 55,
Yes.
the revised development scheme is slightly less profitable than the original would have been. Sorry, no, he's not, is he? I'm just trying to understand what he means by profit.
He's saying, my lord, this. Both schemes were profitable. As a percentage, looking at return on capital employed or return on equity, if you were sitting in some merchant bank and saying, how profitable is this scheme? You'd say this scheme is slightly less profitable in terms of percentage than the other ones, but they're both good schemes. That's what he's saying. Now, my lords, I've made really the points I want in relation to this, but we say with the greatest of respects to the learned friends that this is simply a nonsense. It is making an assumption which is fundamentally false, and it ignores the laws of market economics, which is that if Barrowfen at any time thinks that it has got a better investment available for its money, it can, if it wants to, sell the Tooting property, buy the better investment, and do so on terms. And your lordships have got all the various points made in relation to that. Unless there's anything further.
I realise I haven't remembered properly what I've been told. In terms of the deduction that Mr. Kramer says should be made, he says you should take into account the future financing costs, capitalised. What figure is given for that? I suppose I should ask Mr. Kramer in due course. He's probably told us many times. What is the capitalised financing cost? Presumably it's not a reflection of the notional equity costs. It would have to be a reflection of...
I think he would say that it would be appropriate to take into account what he would say would be the then current costs of borrowing as at 2021, i.e. the Barclays loan and so forth, together with the notional return on equity before one would give any credit. I think that's what he'd say, but I don't want to put words into his mouth, though.
Yeah, it's those two rows in that table.
Which
4 and
table?
5.
The one which leads to the 959.
So you take account of 5, even that's just an opportunity cost. That's not a real cost.
Yeah. Well, I'll address it.
Well, that's the answer. Well, look, I'm anxious to help you further if I can help you further in relation to this. But my submission, well, I'm sure you've got my submission. My submission is that this is frankly smoke and mirrors, and that one is looking at something which has got a value in March 2021. You can look at it in different ways and so on and so forth, but that's the essence of it. And all of this is different things. My Lord, I do want to take some points on a few points on the authorities, and in particular just have a look at the Stanford case. But I'm anxious equally that if there is anything on the what I call the logic of the appeal, I'll address it. Very good. Well, the authorities. I've said what I wanted to say in relation to. I've said what I wanted to say really in relation to British Westinghouse. British Westinghouse really doesn't help you at all. The Lordships may or may not be interested in knowing, but of course these turbines, particularly the Parsons turbines, were being purchased for the Locks Road powerhouse down by the river. And the Locks Road powerhouse has finally been redeveloped as a rather chic development. If any of your orchards are looking for a rather high volume flat. And there is in fact still one of the Parsons turbines in the turbine hall in there. So there you are. It's available for inspection if you want to look at it. I don't propose to say anything else about the Bridge Westinghouse. My lords, I've taken you to the part of the Bunky case from where Lord Toulson particularly explains the nature of what is meant by speculation. Like my learned friend, I don't propose to go to the Golden Victory. I've taken you to what I say is the essential test in Fulton, which is Lord Stone at, Lord Clark. Lord Clark at paragraph 29 on 176, and I don't propose to go over that again. On Harbert's plasticine, your lordships have got the essential point in relation to Harbert's plasticine. They had no choice, and that's apparent both from the judgments of Lord Denning and from the judgment of Lord Justice Cross. They couldn't rebuild the factory with its original 5 stories, and no one put forward any calculation. It is, as observed yesterday, the equivalent of having to go first class when Sladley, the third class train, which are otherwise going on, gets cancelled. My lords, the case which I want to spend just a little bit of time on, because it may help to understand what it is that's being said, is the Stanford International case, which is in bundle 2 of the authorities at tab 16. Now, as my learned friend said, the facts of this case are rather off point. What in essence this case was about was where you've got a Ponzi scheme in circumstances where it was being alleged that a financial institution should have stopped the merry-go-round and held back money which was being used to pay off some of the lucky people who had invested in the scheme and new money had come in, whether in those circumstances the liquidators could sue for the lost chance of only having to pay out those creditors a dividend of a few pence in the pound, which would of course have the consequence that other creditors who got into the Ponzi scheme later also would have benefited from a dividend of a few pence in the pound. So the facts are very different, but that's the background to what is being discussed there. And during the course of the judgment, his judgment, Lord Legate went on something of a deviation in terms of explaining various concepts, and he starts on page 542 by dealing with the so-called breach date rule. And at paragraph 43, he says, sorry, this is page 542, he says that there is no general rule that loss caused by a breach of duty is to be assessed at the date of the breach, and he gives the example of personal injury cases and so forth, and then 4 lines up from the bottom, the reason why in some cases, for example, cases involving loss or damage to goods, is it's often appropriate to take a valuation date at or near to the breach is the effective rule which I will call the market mitigation rule. This rule is where there is an available market in which an adequate substitute can be obtained for goods or services, or which the defendant's breach of duty deprived the claimant, damages are to be assessed as if the claimant entered into the market and obtained such a substitute at the earliest reasonable opportunity, whether or not the claimant did do so. And he gives examples of that by reference to the Sale of Goods Act. Now, just pausing there, the relevance of this is that he then goes on to discuss both mitigation and the meaning in this context of reasonableness. And he makes very clear that there is a difference depending upon whose view you are taking matters from as to what is meant by reasonableness. So it may be perfectly reasonable from the point of view of an individual plaintiff not to enter into the market. But the point is that if he doesn't enter into the market and he thereafter makes either a profit or a loss, that is not for the account of the defendant. In other words, one is in danger. When my learned friend talks about it being perfectly reasonable for Barrowfen to do this or the other, he is mixing up the concepts of what Barrowfen can lawfully and properly do with its directors acting according to their duties and acting reasonably with the legal consequences of events. And after discussing the golden victory and what is meant by that, one sees him coming to discuss this rather yes. He comes to discuss the argument in relation to the net loss position at paragraph 55 at 545. And what he says there is that the basic rule that applies in awarding damages for breach of contract, or in tort, is that losses and gains arising from the breach must be netted off against each other, and only any net loss awarded as damages. So what he's doing is he's saying that the starting point is the net loss rule, and he then identifies the well-known passages from British Westinghouse where it is said that damages are compensatory, and he then says in that case, applying this basic rule leads to the inexorable conclusion that SIB in this case has suffered no loss. Now, my lords, he then, or rather more accurately, previously, develops his thinking in relation to that in the next case, which is another decision of his, this time at first instance, which is the Thai Airways case. And
well, he can't be developing his thinking because that's 7 years earlier.
his thinking can be seen to be explained. Foreshadowed is the word I was thinking.
Foreshadowed, yes. But it's not a development.
It's not a development.
No.
Not even I wouldn't try and say that this could be causally linked. And what you see is him discussing the question of law in relation to mitigation, and he starts off by doing that at page 579, paragraph 31. And 579, page paragraph 31. And what he does is he identifies the well-known 3 rules, and then at paragraph 33 he says that whilst distinguishing these rules may sometimes be useful, it's important not to lose sight of their underlying unity. And the essential purpose of the mitigation rule is to identify, in the light of what the claimant has done or not done to avoid loss resulting from the defendant's breach of contract or other illegal wrong, which costs and benefits accruing to the claimant to be treated as the consequences of the defendant's wrong, or which should be treated as caused by the claimant's own action or inaction. And the basic test is whether the claimant has acted reasonably. Then there is discussion of that, including a citation from a learned friend's book, and he then makes at paragraph 34 the point that is well known, which is the idea of there being a duty to take reasonable steps is not the case. And then, importantly, we say at 35, we see various norms of reasonable conduct have become settled. Foremost of these is the expectation implicit in the market measure of damages that where there's an available market, the claimant will go into the market as soon as possible and obtain a substitute for the performance. And 36, where there is no such established norm, there's a general expectation that where there's more than one option, the claimant will adopt the one which is or is likely to be the least expensive. And then 37 in my submission is important. One result of these rules is that the claimant may have acted in a way which was reasonable from the point of view of its own business interests or personal objectives, and yet not adopted what the law regards as a reasonable response to the defence's breaches of a contract or other wrong. That was, for example, the case in the Elena and D'Amico, where the claimant's decision not to charter a substitute vessel when the defendant owner wrongly turned to the time charter was found the arbitrator reasonable from the point of view of the claimant's own business interest, was not in accordance with the expectation of the law the claimant would take advantage of an available market. And then you get the well-known point that the standard of reasonableness is, however, applied with some tenderness towards the claimant. So what the judge is there doing is identifying that reasonableness is not to be looked at by saying Barrowfen are being unreasonable in holding on to this by some standard applicable to what their directors want to do, but it is from the point of view of expectation of law and allocation of consequences. Now, just pausing there, before we go on to the passage my learned friend relies on, that is in full accord, both we say with common sense and with legal expectation. On Barrowfen's case in this trial, they always wanted to develop the property. They were prevented from developing the property by 2 years. They then did an alternative development scheme, which took longer, cost them more in certain respects, that gave them a bigger asset. And then, at the end of that, they were again back in the position they should have been in, but for our negligence. At that point, they are to be treated as if they are free to do whatever they want with the asset. And in my submission, when my learned friend then tries to assert that he can rely in the context of the seats being supplied in that case with the idea that it's only if you can assess reasonableness by turning an asset into money that there should be some different test, that makes no sense. Can I also just show you paragraph 43, 583. In terms of the principle established by the case, I don't think it matters which of these views of the matter is correct. It's important to recall that, as mentioned earlier, there's often a range of responses reasonably available to the claimant. In such a case, in order to displace the balance of actual loss and gain as the applicable measure of damage, it's necessary for the defendant to show that the action taken by the claimant was outside the reasonable range. The possibility of making more than one reasonable response to the breach open within this party is recited in Viscount Haldane's submissions. Then we get at 584 to the passage dealing with collateral benefits. And in relation to collateral benefits, he identifies some of the relevant issues, and then he gets to credit for betterment at 589. And it is this passage which my learned friend was seeking to rely on. And one looks at 66, where Mr. Morpos submitted the principle that benefits must be brought into account doesn't apply if the only action which the claimant will reasonably take is an incidental additional benefit which the claimant didn't seek. And he then relies on two authorities. And he goes through those authorities and gets back to Harbert's plasticine at 72 on 591. And at 74 on 592, he says it doesn't explain the results, and he goes through explaining British Westinghouse. And at 76, where a claimant as a result of a step reasonably taken to mitigate its loss receives money which it wouldn't have received if the defendant performed the contract, justice requires the sum received to be brought into account. This is because money is entirely fungible. Generally no material difference between incurring a cost which results in the receipt of money back and simply incurring a lower cost. And then he deals with confirmation that credit must be given for monetary benefit even if it's an unavoidable consequence. And 78, he talks about the Westinghouse case in the Baltic Surveyor. And then 79, Baltic Surveyor and Harbert's plasticine are best explained on the bet claimant didn't obtain any proven pecuniary advantage. Well, just pausing there, we've looked at Harbert's plasticine. That's a case where there's no choice but to rebuild the two-storey factory instead of the five-storey factory. The Baltic Surveyor is a case where a former German motor torpedo boat, which is moored by a pontoon, gets hauled by the mast of a yacht which is negligently moored to that pontoon. And unsurprisingly, there wasn't a readily available market for former German motor torpedo boats, and there had to be quite a lot of work done before one could deal with a replacement. And in our submission, that has no relevance to the idea that this is some sort of displacement of the market rules. And then at 81, which is the critical factor, by a monetary benefit, I mean a benefit which either takes the form of money or which the claimant could be reasonably expected to realise in terms of money. Now, my submission is that looking at the entirety of this judgment, reasonableness is not to be judged in this context any more than it is elsewhere from the position of saying this claimant was unreasonable and so forth. It's a legal question as to whether or not the benefits are available to him. Now, picking up a point which my Lord Justice Lewis made yesterday, this company wants money. It wants money for the trust funds which own it. It doesn't care whether it has a property in Tooting, a property in Scotland, or a property anywhere else. It wants money. It is quite capable of taking its own decisions as to whether or not to continue to invest in Tooting or not elsewhere. It cannot be said that deciding to continue to invest in Tooting is unreasonable from the point of view of the company. But what is unreasonable is to visit the consequences of that decision upon my clients and saying that you can ignore the fact that the claimants can, if they wish to, sell this asset, get all the funds they put in and redeploy them elsewhere. And in my submission, read properly and looking at the whole of the judgments of Mr. Justice Leggett in that case and understanding what he means in this context by reasonableness, that's what he meant. My lords, that is all I wish to say in relation to the response to my learned friend's appeal, subject, of course, to anything from your lordships. That leaves our appeal. I do something I haven't done thus far, which is turn to our skeleton argument. And you will find our consolidated skeleton argument at tab 4 of bundle 1, starting at C44. And we start the dealing with the grounds of appeal at C49 at paragraph 9. Can I say, first of all, what our case in a nutshell is as a matter of logic? I then propose briefly to deal with the judge's reasoning in relation to this by reference to the skeleton. I then propose to take you to what we say is an excellent decision of His Honour Judge Russon, which correctly identifies the relevant provisions. I should tell my learned friends have put in the bundle an application for permission to appeal from that decision. We've looked and have no idea what the status of that application for permission to appeal is. It doesn't appear to be on Case Tracker. Obviously there was a notice to appeal issued, but I can't help you as to where that is.
Do you know what date it was issued?
Sorry?
Do you know what date the notice of appeal was
It's
issued?
in the bundle, so we can give you the date.
Don't worry. That'll be some indication.
And I can give it to you in a minute.
Don't worry.
We do say, and I'll take you through his reasoning with a little bit of care, that he has got the legal reasoning in relation to this precisely right. Although Mr. Justice Newberger, as he then was, didn't have the benefit of the relevant authorities being cited to him, we also say that he got the decision precisely right. Just so that I can be clear, we also say that what we are submitting is entirely consistent with the decisions of this court in Hartley and Lacey and with and of this court in the Ministry of Defence case. But what I propose to do is deal with the matter as a matter of logic. Mr. Justice Russon, sorry, His Honour Judge Russon, does deal with both of the two Court of Appeal decisions, and in essence, I will be saying that his reasoning should be applied here for reasons I'll seek to develop. Oh, sorry. Oh, my lord, I'm sorry. What's gone in the bundle, I hadn't realised the date of it, was an application to His Honour Judge Russon, which was back in May of 2022. So it rather looks as if it hasn't got any further. It hasn't got any further by the looks of it, because someone would imagine that.
Well, I say, with the decision of that date,
Yes.
absent some extraordinary
Yes,
extension
quite.
of time, one would have expected an application to this court to have been made and processed
Yes.
long ago.
Yeah, I agree, my lord. I'm sorry. For some reason, I got I had the impression it was later, but that's right. So it looks as if it wasn't appealed, or if there was any appeal, it wasn't progressed. Now, the logic of the position. The damages for which my learned friends seek recompense are based on the lost chance of carrying out the amended original development scheme. And as your lordship knows, the judge dealt with that in two parts. He found that there was a 60% chance that the property would have, sorry, the company would have been in the hands of the rightful shareholders by September of 2014, and development starting in January of 2015. And then he held that there was an 80% chance, necessarily in of the 40%, that if that hadn't happened, the company would never have gone into administration, and the development would therefore have started in March, I think, of 2016, and finished in at the end of 2017. And obviously the figures in relation to the second are lower, principally because the lost chance to obtain that is a loss in relation not of 54 months but of 33 months, so the capital sum is much lower. For present purposes, I only remind you of that so that we've got those two.
The capital sum, you mean the aggregation of lost rent?
Yes, I do. And also to remind you, and I know your lordships have this, the claimant sought and was awarded 100% of the 399,000, which was the cost of change. So that's what they were awarded. Now, they got, assuming I succeed in persuading your lordships on the appeal we've just been dealing with, a benefit of £2.5 billion as at March of 2021, because they had an asset which was more valuable to that extent as at March of 2021. That is an actual asset which is in their hands and they have obtained. The central fallacy which the judge fell into was in finding that the chance of obtaining the lost rentals and so forth, 60% and then the 80%, was the same as the inverse of the credit. Putting it another way, the only reason that the credit was obtained was because the development actually went ahead. In an alternative universe, for example, the 40%, as is apparent from the judge's judgment, carries in fact all sorts of things. It carries the central thesis is that Girish would have accepted our advice to go to an independent solicitor. And if he doesn't do that, what does he do? Does he come to an agreement with his brother's nephew? I might say there's a pig flying past that window, but it was certainly one possibility. Does he agree on an overall settlement of the family assets, which had been in discussion from 2008, and where essentially the understanding had always been that Girish would be doing the development in Tooting and they would be concentrating on assets elsewhere? Do they decide to sell the property? Do they put liquidators into the properties and decide that all of their family businesses are going to be wound up? Do they decide to do another development altogether? Now, none of those consequences carry with them the idea that you are going to get this credit. In other words, the inevitable consequence of going ahead with the amended original development scheme is that you obtain this benefit, but it is not the case that in the 40% and then the 20%, you don't get the benefit.
Sorry, to say that again.
It is not the case that in the alternative universe represented by the 40%, it may be easier just to deal with one loss of a chance rather than two, or the same principles apply, but in the alternative scenario of the 40%, they don't get the benefit. So can I give you by way of an analogy? In Hartles, as we shall see in a minute, what happened was that the negligence of the defendant solicitors meant that where someone bought a property which had a restrictive covenant which hadn't been registered attached to it, the solicitor instead of saying to his client, "You're jolly lucky this restricted covenant hasn't been registered. Quick, go ahead and sell it," promptly tells the vendor about the restricted covenant, who then looks at it and says, "I haven't registered," and promptly registers it. In doing so, as the judge finds, the plaintiff loses the opportunity to sell the property at, the judge found, £375,000. He's still got the property, and in due course, the property is sold for £150,000. So what is lost in that situation isn't a chance just of 375. It's only the difference between 375,000 and £150,000. There is no such analogy here. Once you are in the situation where the the revised development scheme goes ahead, you get a better and more valuable development as night follows day. And it's not a situation where you would have got that benefit anyway in an alternative universe.
So can I just try to talk around this for a moment? Let's leave out of account, just for the moment, the 32% chance.
Yes.
So suppose it were only the 60%. So the judge says there's a 60% chance that if things, but for the breach, you would have got the original scheme, amended original scheme, completed by such and such date, and therefore you lost rent. So suppose that hadn't happened. So as you say, we're into the 40%. And as you say, let's think about what might then have happened. And this is where my grasp of the facts isn't good enough. Is it accepted? Is it right or wrong to think that a possibility at least would be that then you would have had the revised scheme on the 40% scenario?
Well, my lord, I suppose theoretically one could have a situation where, for some reason or another, without any delay, Girish or his brothers suddenly look round and say, "Do you know, actually, we think we might be able to get a better scheme, even though we've got Waitrose nagging at the corners, etc., etc., and we'll go ahead with this scheme." Now, that's not the way the claimant put the case for the first possibility. It is, in my submission, extremely unlikely. I can't say there is absolutely no prospect of it at all, but the central point, and this is the one which I'm going to come to, is that the judge wrongly assumes that the chances of that are the same as the chances of the amended original development scheme going ahead. In fact, my submission would be on the facts; they're nil to non-existent. But there is no assessment of that. There's no case being put forward. Oh, well, you'd have got this in any event, and it would have been an extremely difficult case to run, because of course the case which Prashant had to put forward and Suresh had to put forward in order to get all of their rent, and which was accepted by the judge, and this is on them as a balance of probabilities, is that in the alternative universe they would have gone ahead with the amended original development scheme. If they'd started saying, "Oh, well, we'd have reassessed in any event," and so forth, then they destroy their own case on causation in relation to the loss of rent.
But I wonder, do we need to get into a percentage of the benefit? Because you've got to the stage that it's reasonable for them to switch a scheme, and the end result of them having switched the scheme is the thing they get is worth more. It wouldn't matter if there was 100% loss of the chance of getting the rent, and they got 100% of the loss, they still have that benefit, and they would be weighed against the other. If it's a 60% loss, it's a 60% loss of the chance of getting the rent, but the benefit is going to be the same, whatever, because once you've gone down the route of saying it's reasonable to do the amended scheme, the revised scheme rather, the factual consequence of that is they have the benefit. And if you're working out what have they suffered, then whatever percentage loss they've suffered by not getting the rents early is weighed against that which they actually have.
That's what I was
That's your
trying.
case,
That was what I was trying to submit.
Oh right, sorry.
But obviously,
very slow.
obviously not very well. But your lordship genuinely puts it much better than I was putting it.
Just reversing back for one moment. So in the 40% world, what would you expect to have happened? I follow that you say this wasn't a case developed by the claimant and so on, but
I mean, it's probably fair at this point to show you the judgment, because there is some discussion about that in the judgment, and it's right to have a look at that. If your lordships would go to the if your if your lordships would go to C454. I mean, the discussion about causation is in several parts, but the starting point is probably actually at C450, when there's the development would Prashant and Suresh have proceeded. And the relevance of this is the starting point for the claimant's case on causation, and as your lordships know from Simmons and Simmons, that's got to be proved by the company on the balance of probabilities, what they themselves would have done. And you see that their case, 604, is that if he'd been appointed as director in May 2014 or afterwards, he would have raised the necessary equity either by a rights issue or a loan from Ankar. And I then challenged those submissions, and I did so. No lender would have been prepared to fund. I challenged it on the basis that Prashant had no intention to develop the Tooting property until Girish had resigned as the director. And what the judge then does is he goes through and looks at the availability of funding and comes essentially to the conclusion that a bank would have been prepared to lend. And then at 614-454, he rejects my submission that Prashant had been opposed to the development of the property, and the judge found that I put that to Prashant very clearly at 614, and I was putting a case that all of this was as part of a plan to capture Girish's assets. I relied on what they'd done in relation to Amcar and the lies which had been told there, and so forth. And at 616, you see the judge saying that he set out his findings in the wider family dispute. He's found that Yashwant, Suresh and Prashant prepared to use the Seychelle's claim to deprive Girish of his 1/3 share in Amcar, or avoid it entirely lawfully by exploiting Girish's decision for the shares in Barrowfen. Found that Prashant and Yashwant backdated documents to mislead the court in Malaysia. And he then says that those provide strong support for the submission, but he accepts the evidence of Prashant and Suresh on the balance of probabilities. That then provides the, and he makes the point at paragraph 619, why would Rajanakant and he turn down the opportunity to develop the Tooting property 619? So he's effectively saying that this is a good property development. I won't give what I told the judge as to why they would have done that, but that's by the by. Then he gets to loss of a chance. And he says that there's a well above 50% that Girish would have taken and followed independent legal advice. There's real and substantial chance that they have taken by the end of September. And he then says, not a case where it's appropriate to assess each counterfactual separately. Say this because they're all steps to a single outcome. The reasons which I've given I consider there's a high probability of this outcome, and I assess it at 60%. Now, what he is therefore doing, in my submission, by the combination of his findings and so forth, is rolling together a number of different factors. So that, for example, if there hadn't been finance available, then the development presumably wouldn't have gone ahead at all. If Girish hadn't taken independent advice, or had taken independent advice but decided not to follow it and forge a few more documents, as was his wont, then the development presumably wouldn't have gone ahead at all, or there would have been even greater delay, or anything of that nature. Now, all of those aren't explored in any kind of detail by the judge, but they lead, in my submission, to very different assessments of the prospects of the chance. And that's, in my submission, about as far as you can go in terms of the judgment.
So you say, at any rate, it is not apparent that there is any likelihood that in the 40% world you would have ended up with the revised scheme.
Yes, I do that. I ought to deal probably with the 32% world. 32% was actually slightly more tricky in some ways because of this. The delay, of course, is only on its face from December of 2015 to September of 2016, because I've already got control of the company in December 2015, and it's the administrators who are going in. They still have the planning consent available to them, and the judge finds that there's an 80% chance that they would have gone ahead and developed the amended original scheme. Of course, there is in that scheme the possibility that there would have been some fundamental rethink, and they'd have come up with something equivalent to the revised development scheme. And I think I have to accept that in that alternative universe. The problem about that, of course, is that that will diminish, probably to vanishing point, the actual losses for loss of rent and so forth, because you've only got 7 months to play with to begin with. And the whole of the nature of the difference really then becomes that that 7 months makes all the difference. That's what causes them to get the alternative scheme and so forth. That then leads to the delays going into COVID and so forth. So I'm in greater problems, I suspect, from a factual point of view at the end of, in relation to 2015, but it's in a...
Sorry, I've lost the thread again. I understand you're saying that the judge has said there's a 60% probability that had the company claims, so had the negligence which comprises the company claims not occurred, there's a 60% chance, is right, that they would have proceeded with the development at the earlier stage, finishing in
September 2016. Yes.
But there's no finding. Sorry, and then so he then says, well, right, assume that that hasn't occurred.
Yeah.
In the 40% that's left of the world, you say that if the negligence which comprises the administration claims hadn't occurred, there's an 80% chance they would have commenced the original scheme, amended original scheme, concluding in December 2017.
Yes, and the factual basis for that is essentially that they'd have started they'd have been in control of the company in December of 2015, and they'd have started the scheme in.
Right, so that's paragraph 630. So we're looking at paragraph 622 and 630. You're saying there's no, you don't say, there's no finding as to the percentage prospect that the company would have done the revised development scheme.
But the point I'm making, there's no findings to that. That's the first point I'm making. The second point, however, is that to do the revised development scheme would have ended up with a period of delay, because they'd have got control in December of 2015. They then had to have done all the things which they actually did in terms of processing the amendments and so forth. So that would have been the same. The 399,000 presumably would have been incurred. The extra time taken for obtaining the planning consent, which wasn't obtained until 2018, the facts which presumably had taken place, and they wouldn't have finished the thing before the end of COVID. Now, I'm not saying there are findings to fact of that event, but if you follow the logic through, that's where you get in terms of.
The problem that I've got is this: I'm not actually trying to work out the chance of the benefit materialising. I know I can walk down the high street in Tooting and it's in front of me. It's not like the leases, the rents. Would I have done it? Would I have got the rents? It's a different exercise metaphysically, isn't it?
Yes, my lord, I'm probably making the mistake of running two submissions into one without clearly distinguishing between.
Oh, right. It's my fault.
No, it's not your fault. It's my fault. It's definitely my fault. The first submission is exactly the one your lordship has made. But the second one is that in order, as it were, to deal with Hartle and Lacey's, I have to explain why in circumstances where there would only be, or put it another way, in the alternative universe, you might have to give credit for it, how the logic it works. And I'm on that second point.
Yeah, and just run that logic by me again, it still would be 100% of the benefit, not something else.
Yes, but the benefit would be different, because what you would be looking at is saying, and taking the Hartle and Lacey's case, that you have you haven't obtained 2.5 million. You're always going to get some proportion of that amount.
Right, so you've got a value, it's a hypothetical word, 60% chance because of the scheme going ahead. What would be the chance of getting the benefit? Yeah,
and just to be clear, so as far as Hartle and Lacey is concerned, you say you don't need to say it's wrong.
I don't.
But
it
makes a lot of sense, doesn't it?
Sorry. Actually, no. Sorry. I do reserve the position to say it's wrong if necessary, but
no. I follow that. Yeah. Yes, I see. So you're not going to agree it makes a lot of sense, but it does seem to make a lot of sense.
I agree it makes a lot of sense for the purposes of this form. If I'm wrong about that and you say no, it's not, then I say something else.
But they're measuring different things in Hartley. As you explained, they're measuring different things in Hartley.
Well, they are.
Is your point?
It is.
Because the base is different. The base is always going to be they've got the property. And then you're working out the loss on top of the property.
My lord, that is right. I would like, I think, probably now to take you, if I may, to his honour, unless there's a question which I.
Well, it was only just. I mean, my understanding is you do not agree with Mr. Kramer's skeleton argument, as I understand it.
It was certainly not.
It's paragraph 18 at page C115.
I absolutely don't agree with that, my lord. That is quite an important point, and I am going to go through the judge's judgment when I
because
deal with it.
As I read that, Mr. Kramer is making the submission that in the 8% world, the judge found that Barrowfen would have proceeded with the RDS and completed the RDS.
Yeah, well, my lord, I don't accept that. I mean, I don't accept it as a matter of fact, and I also don't accept it that that's what the judge finds when one takes the judge's judgment. I think what
and in fact, I think you say it doesn't matter anyway. But
what I'd like to do, if I may do, is take your lordships to His Honour Judge Rushton's decisions. Well, really because he expresses the logic of what I'm trying to say. Then I need to take you to the judge's decision and show you what he actually found. And then I need to sit down to make sure this appeal finishes today.
Well, we also need to look at Hartley, don't we?
We are going to have to look at that.
Right.
I will do
Because
that.
we are bound by that, whatever I think.
Yeah, you are, and so am I. Yes, can we have, please, now there are two quite lengthy decisions in the bundle of His Honour Judge Russell. And can I just explain to, and they are in the second bundle of authorities at in the first bundle of authorities at tab 13 and the second bundle of authorities at tab 14. Can I just explain to you what was going on in the case which the judge had to decide? This is the case of Richards against Speechley Bircham, and as in this case, you have an initial judgment, which is the one at tab 13, and then you get a subsequent judgment, which deals with consequential matters at tab 14. And what this case was a claim against solicitors who'd acted in respect to losses suffered on the sale of stakes in a cloud-based communications technology company in December 2014. And what had happened is that the founders of those companies had entered into terms whereby they got an initial substantial amount of consideration, and they then were entitled to retain shareholdings with values attached to those shareholdings, provided that the value wasn't destroyed in certain events. And one of the events where it could be destroyed was if the shareholders were bad leavers. And that was understood. What actually happened was that on the construction adopted by Mrs. Justice May, she first of all found in the action between the vendors and the purchasers that the directors and shareholders had been good leavers, not bad leavers. But she nonetheless found that on the proper construction of the contract, the value of their shareholding was essentially nil because of valuation rules in the sale contract. And their claim was a claim against their solicitors for failing to warn of the risk that even though they might be good leavers, there were certain circumstances in which the value of their shareholding would be reduced to nil. Now, it is fairly plain from certain parts of His Honour Judge Russon's decision that he wasn't entirely ad idem with Mrs. Justice May as to how the contract worked. But nonetheless, he found, unsurprisingly, that where there was a fought-out case between sellers and vendors, and where the end result after a full trial before a High Court judge was that they ended up with nothing for their subsequent shareholding in these rather unusual circumstances, the solicitors were guilty of failing to warn. And therefore the question arose as to what would have happened if an appropriate warning had been given. So that's the factual, slightly complicated factual background which is being dealt with. And their case, their primary case, was that if they'd been given a warning, a carve-out would have been agreed with the vendors of the shares, and therefore the problem would have gone away. The alternative case was that if that hadn't been possible, they'd have walked away from the investment and sold to an alternative investor. And for reasons which it's not necessary to go into, the judge found, in fact, that there was no real prospect of a carve-out having been agreed by the vendors, and therefore one was left with a situation where the claimants would have walked away, and the question, therefore, is what would have happened to the value of their shareholding. There was, as I say, litigation between the sellers and the vendors, and they appealed the decision from Mrs. Justice May. They compromised the appeal, and they each got £87,500 by way of compensation for the prospect of the appeals. And the crucial findings are at page 391. This is, sorry, the first judgment, the first bundle of authorities. Paragraph 388. He finds that the claimant should have been warned of the risk, and at 393, and he finds that a significant risk went unspotted. That's on page 394, paragraph 393. And then he goes on to deal with causation, starting at the very bottom of 394 and following onwards. He finds that the buyers would have walked away. That's at 399 on page 395. And at paragraph 415 on page 398, he finds that there was no real or substantial chance for the purposes of scenario 1, that's the carve-out, and they then doesn't deal with, and then he evaluates scenario 2, and the scenario 2 is the prospects of an alternative sale. And the headline conclusion, after going through all of the evidence of this, is that he's looking at the evaluation of a chance of securing £8 million for their shareholding. You see at 448 on the betting 404. And he then assesses that chance at 450. He assesses the chance the claimants would found a buyer for their shares at the price of £8 million under a purchase valued at £9.4 million at 75%. So he finds there's a 75% of an alternative buyer at a figure of £8 million. And he then deals with legal fees which have been totted up in relation to them, and he gets to his final conclusion in relation to the credits which have to be applied by looking at the amounts which they received in the original transaction and the amounts which were received in relation to the sums under the settlement of the Court of Appeal, and his final award is 1.45 million, having taken account of those matters at 514. What then happens is that there is an argument on consequential matters, and in particular an argument that he has wrongly treated the credits which are made forward, and the judge deals with that. The judge deals with that in his second judgment, which is to be found at tab 14 in the second bundle of authorities. And one sees paragraph 59.
Come on, there's been a bundle failure.
Oh, I'm sorry.
Second bundle, yep.
Tab 14. And the contention is, at paragraph 59 on page 437, that on the findings of the judgment, the correct calculation of the damages is not 1.454 million, but 2.646 million. In other words, the claimants were asserting that the judge had applied the settlement sums wrongly. And he starts off by saying that the draft judgment had referred to the 175,000 settlement sum as being common ground. That's the 2 times 87, which is the settlement of the case in the Court of Appeal. And he says that hadn't been flagged, but he's going to deal with the matter. And then at 61, he says, at paragraph 478 of the judgment, I applied the evaluative figure of 75% to a shareholding figure of 8 million to produce the sum of 6 million as the headline figure for the loss suffered by the claimants in not turning their shares into cash under scenario 2. At paragraph 479, I did the same in relation to the figure of 300,000 as being the liability for the identification of costs. I then applied the credits for the cash received under the transaction and the later settlement of the appeal and the legal litigation. In other words, he'd done precisely what we say ought to be done in this case. The claimants say there was an error in my approach. The figure of 75% should have been applied not to the 88 million valuation, but before then debiting in full the cash of $4.595 received under the company from transactions. Just pausing there, that $4.595 million is effectively what they got as the initial consideration under the sale agreement. And that produces a figure of 2.5 million, and one sees the same approach being said. And then it said, this approach is said to be correct by one of the references to a passage in Jackson and Powell on professional liability, and the decisions of the Court of Appeal in Hartle and Lacey. And there's then a short passage from Jackson and Powell, and then he analyses it. The claimant's loss under scenario 2 reflects their lost chance of receiving more cash for the sales in IPS UK than they in fact received on the transaction, and also their lost chance of avoiding the costs of the quantum judgment. In accordance with the approach described in Jackson and Powell, the 75% figure has been applied to reflect the 25% uncertainty over them realising the full value of their shareholding, on the basis they're worth 8 million, and avoiding those costs on the basis they were 300,000. No such uncertainty over the sums they received from the company, under and as a consequence of the transaction, which actual receipts to be set against the scaled-down damages. In my judgment, the flaw in the claimant's approach is revealed by the application of the 25% discount after inclusion of the credits for the cash consideration and settlement monies. This involves treating their receipt of those monies as being subject to the same degree of uncertainty as that which reflects their chance of realising the full 8 million of their shareholding. Another way of reaching the claimant's figure is to deduct 3.4, the figure of 2.5 is to deduct 3.446, or 5 times 75%, from the 6 million, which represents the value of their chance. Yet there was nothing contingent or hypothetical about the claimant's receipt of 4.595. It stands unaffected by the hypothetical assumption the claimant should have cashed in on that chance, and therefore shouldn't form part of the scaling down process, which, as Jackson and Powell states, rests upon an assessment of what that chance was, as opposed to recognition of an indisputable fact. And then he deals with the two Court of Appeal authorities which have been cited to him, and Hartle and Lacey. And in 68, he identifies the facts of that case and sets it out, and he goes on to do that. And then at 72, as Lord Justice Ward recognised, the choice between two options was not an easy one. In a case relating to the lost sale value of an asset, where the later receipt of 150,000 for a property retained after the date for assessment of damages was a matter of undisputable fact, the case for instead adopting the first option appears to have been a strong one. I would add that my assumption would be that it would be right for the components of the applicable formula to be treated consistently, and he identifies that. Further, if the first option was adopted, it would appear to be no case for then discounting the interest payable on the damages over the period between the hypothetical sale and the actual sale by the same percentage discount. And then he notes and observes the claimant hasn't lost the property, which sold for some years later at 150%, and he identifies in paragraph 74 that the value of 250,000 was delayed is dealt with elsewhere. As the defendants suggested in their response submission, this is paragraph 75, the logic to support the adoption of the second option would be that if there was a 60% chance of selling the property at 360,000, then the same percentage governs the claimant's chance of selling for 150,000. For the purpose of the counterfactual, properties to be taken to have been sold at the earlier date couldn't be sold twice. By reason of the defendant's negligence, the claimant gained a 60% chance to receive 150, which had not even existed in the non-negligent counterfactual scenario. And note the court didn't apply a 40% chance to the sale of the lower price, which the relentless pursuit of such logic to mutually exclude itself might suggest. And he then goes on to make the point, in this case the claimants did lose their shareholding, and the essential conclusion at 79 is that having received 100% of the proceeds, when it's been established on the balance of the list, the claimants would have walked away. It's only the prospect of securing that alternative which falls to be evaluated in percentage terms, but they must give full credit for the sums received under the transaction against the sum reached through the process of valuation. And he says the same approach applies to Ministry of Defence against Wheeler. We say that analysis is correct, and we rely upon it. We also, if I can come back to our skeleton argument at tab 4. if I can just take you through our skeleton in order to show you what we say are the relevant parts from the judge's judgment. Can we go to C51, please? Paragraph 13. And the critical point we say at the top of C52 is that our negligence had lost Barrowfen the chance to complete the amended original scheme in September 2014, respect to company claims, and April 2016. That's the categorisation of the loss. And we highlight the passages in the judgment which are underlined, 621, and particularly 622. In my judgment, the appropriate course is to assess the overall percentage of likelihood of this final outcome, and therefore assessing the chances that Parash and Desurish would have taken control of Barrowfen and proceeded with development. That's what he's assessing in the first judgment. And with the administration claim, you see that he says that he's satisfied 629 that Barrowfen would have commenced by April 2016 the AOS, and that Barrowfen would have avoided administration and begun the OAS by April 2016. But then in little b, in the reserved management judgment, he says the opportunity that was lost was the opportunity to develop the Tooting property 5 years earlier than it did, and the value of that opportunity is to be assessed by focusing on the entire picture. And then he says, in my judgment, no relevant distinction between the present case and Hartle's. They lost the chance to sell, but didn't lose the property itself. What he lost, therefore, was a 60% chance of achieving a better price at an earlier date in time. In our submission, that is inconsistent and illogical with what in fact he found, which was the chance to take a particular development scheme. We then say that the correct approach is to characterise the chance as to complete the amended original scheme only, and we then say that where the claimant loses its chance, the correct approach is option B, as set out in 15. Now, my Lord, we do cite the decision of Mr. Justice Neuberger in Harrison and Bloom. That is an interesting case where the two sons of the late Ernest Harrison, who was the chairman of RACAL and the first chairman of Vodafone, decided when they were quite young to enter into a business. However, it's the decision of Mr. Justice Neuberger where the relevant decisions were not cited to him, and the logic which is put is no better. And although Mr. Justice Neuberger is always a good judge to cite, all I really say in relation to that is he came to the same conclusions, but he doesn't deal with and grapple with the authorities. And so I will, if I may, leave the matter so far as we're concerned by what we say in relation to the skeleton in Harrison and Bloom. We have set out the relevant passages, but frankly, if I don't get home on the reasoning of His Honour Judge Russell, I'm not going to get home in relation to reasoning of Mr. Justice Neuberger when he doesn't refer to the relevant authority.
And frankly, in the end, these are first instance authorities. It all depends on the reasoning rather than
It does, my Lord. It does.
source.
Now, I've taken you through Richard's Speechley Bircham at 19, and I'm not going to go back over that. I then sought to summarise the differences, or we sought to summarise the differences and our submissions in relation to that 21 to 27. Can I just point out one, obviously, illogicality? Claimant claimed as awarded 100% of the costs of pursuing the RDS. We'd say it would be plainly illogical and inconsistent to award 100% of the cost of the action while discounting the actual credit received in relation to that, and that's paragraph 25. And I am also going to deal with the Hartle and Laces by reference to our skeleton, if I may. Hartland Laces is at 30. I've already given you the essential facts, but they are those which I've stated, which is that the restrictive covenant leads to effectively the loss of an opportunity to sell. The transaction was taking place in June of 1988, and to those of us who bought houses in June of 1988, we well remember that
Double
the
Morris.
market took some time to recover after those particular matters. And just to emphasise some points, 31, Lord Justice Ward categorised the lost chance of selling the property before the market slumped. And therefore the lost chance was the lost chance to obtain the difference between the possible amount received and the credit. And we identified that in paragraph 32, and for what it's worth, we rely on Mr. Simpson's excellent rival to my book in Professional Liability, where that's what he says about it. And we identify again the passage which you've already seen, that the claimant didn't lose the chance to sell the property, certainly didn't lose the property itself, paragraph 33. Ministry of Defence and Wheeler, this is a case where the claimants in an employment context lost the opportunity to say in the armed forces, but they were still able to have employment in civilian life. Again, we say that the consequences of the breaches which took place unlawfully on sex discrimination grounds, which led to them losing the employment in the armed forces, didn't destroy their entitlement to in turn any wages. All they lost was the opportunity to stay in at higher wages that they would have earned within the armed forces. And in our submission, Ministry of Defence doesn't take the matter any further. And I have taken that something of a gallop for reasons which I'm sure you will understand. But just to summarise our two essential points, the first is the one which was summarised by Lord Justice Lewis towards the beginning of my submissions, which is that in this case you've got an undisputable benefit which has actually occurred as compared to the lost chance. The second is the second one, which is that here what one is categorising is the lost opportunity to do the amended original development scheme, but you don't get corresponding benefits in the what I'll call the 40% universe, or the 20% of the against the 80%. And the logic, therefore, is that the whole of the credit should be applied after the application of percentages rather than before.
Can you just give that second proposition again? The lost opportunity to do the amended original scheme, and therefore you do not, you said?
The lost opportunity to do the amended original development scheme, therefore you do not assume that in the what I'll call the 40% world, you would have obtained the credit.
So just talking around, I know we have already, but just going back to that a moment. So 60% chance they would have proceeded with the amended scheme and achieved that by a particular date. Supposing, as you say, contrary to the fact, that the judge had found that in the 40% world they would have achieved the revised scheme by the end date, how would that play out?
Well, that's fatal to the argument that I'm putting in relation to it.
Yes. So it all sort of depends on what Mr. Kramer categorises as his 8%.
Yes. You need to be quite careful because it's not 8% of the same thing.
No, I see. It's either the 40% or the 20%, but
it is literally apples and oranges. But it's but anyway. But your but yes, that is The conceptual point is the one that you've just identified.
That's the paragraph 18 point from
Yes.
Mr. Kramer Skeleton.
Yes, it is. My lords, I apologise both to you and to my learned junior, who I grossly misled as to the time at which I would sit down. But if there's anything more of the main appeals,
Thank you very much. Mr. Volkart.
My lords, I'm opening Stevens and Bolton appeal on ground 5, relating to Mr. Justice Leech's determination of interest in oral judgments given on the 24th of May 2023. My lords, could I just check what time you'd like to break for lunch before I get into the detail? We'll be going until 1.
Definitely till 1. And obviously, I haven't worked out the precise maths. The overall intention was that the two sides should get the same amount of time. So on the assumption that we finish by absolutely no later than 4:30, I'll leave you to work out at lunch how long that gives you.
I'm very grateful. Thank you. So, my lords, we do not have a transcript of those oral interest judgments due to some poor quality sound recording. What we do have is a note of those judgments agreed between Barrowfen and Stevens and Bolton, which was subsequently approved by Mr. Justice Leech, and that's at Core Bundle 2, tab F20, page C608. That, of course, doesn't cover the submissions which were made. If I just give my lordships the references, I'll then take your lordships through those documents as necessary later. On the submissions, what we have, for what it's worth, is an email exchange between myself and Mr. Mathewson, setting out our recollections, which differ slightly, of what happened. And again, for the note, that's the supplemental bundle, tab 38, page S388. Now, as I said, I'll come to those, but I'd like to start, if I may, with the single-page, multicoloured E2's interest diagram document. Could I just check that your lordships have that? I also have, if it would assist, some copies in A3. I don't know if the text is getting too small.
I think it's all right. Thank you very much.
Okay, thank you. Now, I'll explain the detailed position by reference to that diagram shortly. But if I could just start by outlining the two crucial errors which we say the learned judge made in relation to interest. The first is that the judge applied a rate which we do not dispute to the wrong base figure. And I'll expand on this by reference to the diagram. But we say that the rate should only have been applied to an interest as damages figure of £337,229. In fact, what the learned judge did was apply that rate to the entire principal sums times the loss of chance percentage. And that mistake gave rise to an error in the magnitude of £167,000 because it was a rate of 2% over base applied to a principal sums of 4 million odd rather than to a base figure of 300 odd thousand. That's our ground 5A. And we deal with that in our consolidated skeleton, paragraphs 41 and 42, and that's at C 64 to 65. The second fundamental error was that even in applying the rate to those principal sums, Mr. Justice Leech should have taken into account the credit which Mr. Stewart and Mr. Kramer have been arguing about in relation to the question of damages. That's our ground 5B, dealt with in our consolidated skeleton paragraphs 43 to 44, page C65 to 66.
So that depends on the outcome of the first ground.
Well, it only arises if you find against Stevens and Moulton on ground 5A, and therefore we are looking at interest on the principal sums, and that's our effectively alternative case, yes. Now, separately from those two complaints, Barrowfen accepts now that there was an error by Mr. Justice Leech in failing to take into account the 1.705 million paid by Stevens and Bolton to Barrowfen on the 27th of September 2022 in satisfaction of judgment on the principal sums. Barrowfen says that would reduce the pre-judgment interest as damages which should have been awarded from £520,014 to, on their case, £442,330. And that calculation derives from the spreadsheet at the supplemental bundle, tab 37, page S386. I should say I've checked with Mr. Matthewson, and it's that 442 figure, not the slightly different 443 figure in their skeleton at paragraph 77, which Barrowfen concede. We welcome that concession. I should say we're not in a position to agree that 442 figure on the hypothesis we lose. We have asked Solicitor for the working spreadsheet supporting that figure, and we hope to be able to do so. But in any event, that won't negate.
So so can you give me the reference again to the skeleton argument where you said there's a different figure? The spreadsheet is at S386.
That's right. The skeleton argument paragraph is 77, page C134, and the figure there is erroneously £1,000 higher, 443.
And this is an entirely independent point of the ones that you're going to advance.
That's right. So if we lose on grounds 5A and 5B, there's nevertheless a concession by Barrowfen that the interest amount should be reduced to take into account payment of the judgment.
And even if you win on 5A or 5B, there's still the extra deduction.
Well, if we win on 5A and we're not looking at the principal sum at all, then it's a different calculation.
Yes, I see.
But if I can assist with that, Mr. Matthewson and I have also agreed that figure, so which would come out if your lordships find for
Yes,
Stevens and Moulton on ground 5A. And Stevens and Moulton agree Barrowfen's figure of £15,455, and that's the figure which derives from Barrowfen's skeleton paragraph 75 to footnote 32. So if I could then turn to the diagram. So the green
we
diagram...
haven't got a transcript. At some point it might be useful to, just to have my note checked against, or at least our notes checked against the various permutations you've just given us. I don't know whether that's possible. Just as it sounds like a sort of route to verdict type document.
Yes.
If X, then Y, if Y, then Z.
Yes.
I don't know whether that's possible to agree those permutations between you, or at least put them on a piece of paper to make sure that our notes...
I'm sure Mr. Matthews and I have been speaking about seeking to agree the figures. The figures on this diagram are actually agreed. It's just that this is not an agreed document.
This document doesn't, I think, include all the figures you've just been given.
That's correct.
References. So I really need both, I think.
I'm sure we can agree there. So on the diagram, the green diagrams at the top represent in timeline form the substantive losses for which Stevens and Bolton was held liable. And as we heard both yesterday and this morning from Mr. Stewart, so the dark green relates to the company claims, in respect of which Mr. Justice Leech found there was a 60% chance that the AOS would have concluded in September 2016. So that's why the rent starts to run from then. And in the counterfactual, Barrowfen would have had the benefit of that income stream of rent accumulating by the time of trial in March 2021 to 4.066 million. The light green is a similar run but relating to the administration claim, where the learned judge held there was an 80% chance that but for my client's breaches, the AOS would have completed in December 2017. So it's effectively the same, but the light green bar starts later and is shorter. But the key point there is just to flag that the vast majority of damages awarded are for loss of a stream of income over a period of several years. Now, with regard to the green text on the right-hand side, this is the interest awarded figures. If perhaps I could just ask your lordships to turn up the reserved matters judgment, which commences, this should be core bundle 2, tab F19, page C603.
Which page?
603. And at the bottom there, number I, we commence with interest. And there are 3 key points here in my submission. The first relates to paragraph 129 on page C605. And that is that Mr. Justice Leech held that Barrowfen had pleaded and proved a claim for interest as damages. And that's important because interest as damages was expressly claimed because Barrowfen accepted that if its only interest claim were for interest on damages, i.e. statutory interest, that interest could only be calculated on the basis that Barrowfen had to give credit for the RDS. And we see that reflected in the 2 paragraphs on the previous page, 127 and 128 at C604. Now that was through Barrowfen's previous counsel, Mr. David, but it will be significant when we come on to ground 5B. The second key point from the reserved matters judgment is at paragraph 133, which is simply that the judge determined the relevant rate as 2% over base, and we don't appeal that decision. The third point brings me back to the table, because at paragraphs 130 and 135 at page C605 and 606, the learned judge gave the base figures on which interest would be awarded, and these are the figures in the green text on the right-hand side. And effectively, I think the only point I need to make here is it's the accumulated substantive losses times the loss of chance percentage. And that's the sum on which interest as damages is awarded. And my lord, those conclusions gave rise to 3 possible awards of interest, and these are represented as they are actually made by the red, blue, and yellow arrows on the diagram. The red arrow represents pre-judgment interest as damages on the principal sums, by which I mean, as I said, the accumulated losses times the loss of chance up to the 22nd of June 2022.
And just talk me through what you mean by that, interest as damages.
Sorry, so that's the Sempra Metals claim, a substantive claim for interest as damages rather than a claim under the statute, section 35A here, for 2% above base on other damages. Yes. Yeah.
Are you saying they should have got the rent if they got the rent, they'd have got interest on the rent? Is it that?
Exactly.
Yes.
So
Right.
in our case, yes, it's a loss of use of the money.
And
in
so
the
it's
form of rent.
accumulating over these periods over which rent was lost.
Exactly.
So it would be less for the last of the 55 months, but a lot more for the first of the 55 months. Is that it? And he's accidentally just given the same for all 55 months. Is it as simple as that? I hate to be simple. I just am.
No, what the judge has accidentally done under Ground 5A is he's plucked the 520,000 figure from a letter which was sent by RPC, but that letter was calculating interest on the principal sums at various dates, and that 520 figure was a date all the way up to the consequentials hearing on the 24th of May 2023. So what the judge did was, on top of pre-judgment interest as damages, the red arrow, and on top of post-judgment interest, which I can take you to the documents on, he then awarded this additional sum, which was based on the 2% above base on the entire principal sums, all the way up to the consequentials judgment on the 24th of May.
Okay. Yeah, I'm afraid you've lost me in the middle of that. I don't know about anybody else. But I understand. Can I tell you where at least I am?
Yeah.
I speaking entirely for myself, I'm sure, but I followed you and to the right-hand side in the green text and the reference to the judge's judgment, which is to compensate by way of damages Barrowfen for not having had the use of money from the rental receipts at an earlier time.
Yeah.
Okay, got that.
And can we just be clear, what sum was awarded on that? That's the 337.
Yeah,
Yeah.
exactly.
I'm with you.
To the 22nd of June,
Yes.
2022.
So that's why your red arrow goes up to that date.
Yes, and we don't dispute that 337,229 figure.
Yes.
Right, so and that is the product of the two things in the green. You don't actually sum them, is that right? That the 337,229 is the sum of that you would get if you did the sums at the right-hand end of the green text. Is that right?
Yes, I think that's right. So the red figure is just the accumulated losses times the loss of chance percentage with 2% over base for the relevant period, apply to that figure.
And we don't need to investigate how it was done because that's all settled.
That's correct.
So what's he done on top of that by mistake?
So on top of that, he's awarded the blue arrow, which is post-judgment interest on the principal sums. So we've got interest as damages running until the 22nd of June 2022 in the sum of 337,229. Then the parties were agreed that post-judgment interest would begin to run from the 22nd of June 2022, and they in fact agreed the figure for that as well, 36,261. That's up to the date of payment by Stevens and Bolton. And so the judge has ordered that as well.
And that's fine.
That's fine.
Yeah.
But we say on the principal sums, that's the only interest which should be awarded.
We're keeping us in suspense. You still haven't told us what he has done then.
Well, let me show you the judgment.
So hang on, could we just...
Yeah.
So it's your bottom yellow or orange line, is it?
Yes, so this is the additional award with which we take issue. Let me just show you the judgment approved note. That's at C609. So,
609.
yes, C609 tab 20 should be in core
The end of the
2.
judgment is 607, paragraph 139 on my copy.
Yeah.
Sorry, this is an approved note of the extemporary
Oh,
judgments
okay,
beginning in
another one.
608.
Yeah.
And if we just look at 609, the bottom of the second section, so the amount of pre-judgment interest as damages will be 337,229 to run to 22nd of June 2022 on a simple basis. No problem with that at all. In addition, it's agreed between the parties.
But sorry, just when he says the amount of pre-judgment interest, he means that's pre-judgment interest as damages.
Yes.
There's pre-judgment damages to compensate for being out of your money.
Yes. Yeah. In other words, it is the red arrow, which it is, and it's the sum of the two green bits in the top right-hand corner.
Yes.
Right.
Yeah. The interest calculation done on those
Yeah.
two green figures. Yes,
Yeah.
exactly.
So, I mean, your box says interest awarded. It should be interest as damages awarded on, interest as damages awarded on, and then that transfers into the red arrow.
That's right.
Got it.
Yeah.
Right.
So then there's also, by agreement between the parties, post-judgment interest on the principal. That's the blue arrow.
Yeah.
But that's the only interest which
Yep.
should be awarded on the
Which we
principal.
went through a couple of minutes ago as you were taking us terribly close, but never quite reaching what the judge has done wrong.
And just to be clear, when you say post-judgment interest on the principal sums, by principal sums, do you include the interest as damages?
Was a very good question. The blue sum, the only difference is that it takes into account the credit. So it's
No, but sorry. By you say the principal sums, do you just mean the loss of rental? When it says post-judgment interest on the principal sums, is that just the loss of rent, or is it the loss of rent including the interest awarded as damages?
just the loss of rent, but with the caveat there's also these miscellaneous costs. For example, the 401,000 administrative expenses.
Why? I don't quite follow why the post-judgment interest shouldn't have been on both the loss of rental
Yes, and the interest.
and the interest as damages. Because interest as damages is damages.
Yeah.
Just like
Yeah.
loss of rental was damages. So why wouldn't you have post-judgment interest on both those?
Well, that's our submission on ground 5A. There can be a third category of interest, but it can only be interest on interest as damages. It can only be interest on the red arrow figure 337229, but not again on the principal sum. And there's two fundamental objections to it again on the principal sum. One is that interest is being awarded twice on the principal sum because there's already the red arrow interest as damages on the principal. So there can't then again be another pre-judgment interest award on the principal.
Hang on. Sorry, they didn't receive the rent up until the date of trial. I mean, it was for periods. Sorry, it was for earlier periods on which they want. So they were out of their money on the rental stream.
Yes.
And they claimed loss of use of that money by way of damages.
Yes.
Right. And so that's the red arrow. That's the pre-judgment interest as damages. So if we'd have stopped the clock and we'd been having this debate between Mr. Justice Leech and you, as at the end of the reserved matters judgment, you'd have said we know exactly what needs to be paid by way of judgment, both as to failure to receive the rent and the interest as damages.
Yes.
Everything is now, this is what you need to pay. And if they'd have said, right, checkbook out, bang, that would have been it.
Exactly.
But they don't immediately pay, and therefore you have statutory interest, as I understand it, on the judgment.
The Judgements Act interest.
Correct.
Yeah, correct.
Which is
the blue arrow.
The post-judgment interest on, and when it says the principal sums, why isn't that on all the amounts ordered to be paid, which would include the interest as damages? That's what I was asking you, because you've used the word principal sums in the red arrow and immediately underneath it in the blue, and I think either you've used it to mean the same things or you've used it to mean different things.
So the only difference between the description of principal sums in the red and the blue arrows is that in the red, it's just the substantive losses times the loss of chance. In the blue arrow, it's each substantive loss less the credit times the loss of chance.
Yeah. Okay, it is me, I'm sure, not making clear the question I'm asking.
Sorry, less the credit. What do you mean by the credit?
The 2.508 million.
Yes, I see. So in terms of the 36,261, which was agreed as statutory interest, is that statutory interest on sums that include the miscellaneous costs and the interest as damages?
Yes.
But not the interest as damages.
The principal sums.
Yes.
Sorry, yes, but not the red arrow. So
yes, I see.
There's only a third category left, which is the possibility of interest on interest as damages. Interest on.
It's got a loss
the
of
red
the use
arrow.
of money because it's making life terribly complicated. There's rent and there's loss of use of money.
Yeah.
And the total is the principal sum that at the end of the day should have been the subject of statutory interest. And was statutory interest paid on the total of the missing rent and the lost money, lost use of money?
Yes, so all that can be outstanding is, we said statutory interest on that 3372209.
Statutory interest on the loss of the use of money, because you've paid the statutory interest on the damages, but you've got to pay, and you accept you've got to pay the statutory interest on not having the money early enough to get
exactly
a return.
But that would only be the £15,000 figure, and not the additional £182,000 figure. And the reason the £182,000 figure in addition is wrong is twofold.
Should we come back to this at 2 o'clock?
Yeah.
Apologies, yes.
What browser is it?